Hello everyone, and welcome back to FOSS, our course on free, libre and open source software. After the introduction, we will now have to cover one of the two basic aspects of open source software, which are the licenses, as well as all the intellectual property issues around open source software licenses. In fact, as we already mentioned before, open source has given us several innovations, and one of them is in the legal space in the form of a creative use of existing laws, in particular copyright law, to give us open source licenses and specifically the copyleft family of licenses. Now, we need to cover some basics first though. We talk about intellectual property, and so first we need to understand property, which is basically some tangible or intangible entity that an owner of that property has rights to. These rights are given to the owner by way of the law, the legal code of the particular jurisdiction, for the property, or that the property is in. Intellectual property then is a particular kind of property, one which is conceptual. It's not tangible, so it's not physical, you can't touch it, and it's usually not fungible, so it doesn't rot in any form. Also, it's usually unique, meaning multiple instances, copies if you will, of the same thing count as one. And so these are not interchangeable, so they are not interchangeable. The rights associated with property, and in particular intellectual property, are so-called exclusion rights. Okay, so there are many rights associated. Those of interest to us here are usually the exclusion rights, meaning that the owner of the property has the right to exclude others from doing something with the property. So you can keep it to yourself and not let anyone else use it. That's your right as the owner of some property, be it tangible or intangible intellectual property. And of particular interest to the upcoming discussion of software licenses are these three types of intellectual property rights: copyright, trademarks, and patents. So copyright is one of these exclusion rights, and it is about the particular expression, the written text. Traditionally, it would have been novels, for example, books, textbooks, what have you. But in the context of software, it will be source code mostly, but can also be graphics, etc. And again, as an exclusion right, it's the owner's right of the copyrighted property to exclude anyone from use, so presentation, reproduction, modification, redistribution, etc. Copyright does expire, so the work after expiration will enter the public domain, meaning there are no owner's rights associated with the work, the property, any longer. The expiration date has been continuously pushed out, so it's I believe 70, 80 years now from inception, and it may well depend on the jurisdiction, or it does actually depend on the jurisdiction for how long these the copyright holds. Under US law, there's only copyright, and you may sell your copyright as the owner, and then someone else becomes the new owner. Germany, in addition to copyright, has something called Urheberrecht. Even after reading the various legal documents, I still don't quite understand the difference. I think for practical purposes, it's not so important. At this stage, having said that, I should say that I am not a lawyer, meaning whatever you hear here does not constitute legal advice. So please don't take it as such. And again, then the interpretation of these rights varies by jurisdiction. So in the US, it might be very different from Germany and might be very different from Ghana. In software, again, user interface designs and source code are the main examples of copyrightable property. Patents are the second, or are a second category of intellectual property of relevance to software. A patent, by definition, is a non-obvious, so the right to a patent you acquire for a non-obvious industrial invention. So the original inventor, if they go and file for a patent, they gain patent rights to that particular invention, again, to exclude anyone else from using that particular invention. The patent rights will eventually expire, and like with copyright, the invention will enter the public domain. This actually was the original motivation for the introduction of patent rights and patent law, to motivate inventors to lay open their invention, because in order to acquire patent rights, you have to, in sufficient detail, describe your invention. And for you to do that, so that it made sense, you would get these patent rights for a certain number of years. Before patent rights, the innovator or inventor would keep whatever they invented secret, and so nobody would ever learn about it until perhaps someone reinvented the same thing. And so the patent right regime was introduced to allow everyone to learn from each other and possibly build on each other. And to motivate inventors, you obviously had to give them something for losing that protective secrecy. You can see a couple of patentable things here. The carabiner, or the particular lock on the carabiner, or to the right, somewhat questionable software algorithms or a workflow here. As we will shortly discuss, there's a struggle in the software industry as to whether software algorithms can be patentable. Industry experts would like to say no. In Europe, it's not possible. In the US, it is possible. In Europe, you may have to go some detour by attaching the algorithm to some physical device, after which it may become patentable, but only in that context. So these are workarounds, and the situation, in my opinion or my understanding, is actually somewhat unclear. Third exclusion rights are trademark rights. A trademark right is given to the owner of that particular trademarkable property, which would be a logo or a particular name, something that is distinctive, a distinctive mark that marks something, for example, your company or its products. So with you owning a trademark, for example, for your a logo for your products, you can then exclude anyone else from copying that logo because it's your trademark. You have to register your trademark, and as long as you keep it in active use it or lose it, as long as you keep it in active use, you will be able to maintain these trademark rights forever. So if it's your brand, your product, then you can use it forever. Examples from the software world are company names like Microsoft, or foundation names like FSF and their particular logos or way of typesetting, etc. So here then is a little quiz for class. In this picture, what different intellectual properties and associated rights can you recognize? So TA, please stop the video and discuss it with everyone, and then I will provide my thoughts on this. All right, so I'm back. You can see copyright here, for example, in the form of the displayed text. This is maybe a book or some story, and there's an author and an owner. of that story, and so this is a copyrightable content, whatever the format it's being presented to a user. You can see the Kindle trademark logo on the front of the case. So this is a trademark owned by Amazon in this case, and so this is another intangible property or intellectual property here. Finally, in the construction of this particular device, there will be lots of patterns. For example, the pattern for the electronic ink, e-ink, that is behind this white display, white low energy consuming display, and this would be just one of many patterns in this example. The intellectual property is covered by law. The rights given to the owner of some property are covered by law, and now owners may want to benefit from the property, for example by loaning the property to someone else who will then pay them for it, or giving someone usage rights who will then pay for it, etc. So for this we need a contract between the owner of the property, who now becomes the licensor, and someone who wants to use the property, who now becomes the licensee. The contract between a licensor and a licensee is called a license. It's a rights grant in which the owner, the licensor, grants the licensee some rights to the property, for example, to use, reproduce, adapt, modify, etc. The particular property. Obviously, the licensor needs to be able to grant those rights, otherwise the license is void. The various dimensions to how these licenses, contracts can be structured along these activities or rights I just discussed, and along various aspects of properties of those. For example, duration, is it perpetual, the license? Can it be revoked? What jurisdiction does it apply to? Just one country or the whole world, etc. Everyone who watches this certainly has already entered into license agreements with providers of intellectual property or just property. And that usually happens by way of end-user license agreements. Even if you've never signed a contract, a license, you have implicitly accepted one. For example, when you unwrap that software package in the old days, or these days more likely when you click through some download or some app installation for your mobile phone. So here, what do you think these license terms actually mean? Please have a short discussion, and then I'll be back. All right, so that's actually what these terms say. Perpetual means whether it's forever or limited in time. Limited in time could be anything, for 1 year, for 1 week, only on Tuesdays, what have you. Can it be revoked? Can the licensor revoke the license? What does it apply to? One country, one village, or the whole world? Is it royalty-free, meaning the licensee doesn't have to pay, or is the rights grant to be paid for? Also, does the licensor receive exclusive rights, or can the software or whatever it is be licensed to many in parallel? Proprietary software usually is not perpetual, though it could be. It's usually irrevocable except for special circumstances. It may or may not be worldwide. But the only thing we can be sure is that it's unlikely to be royalty free. You have to pay for it. And most certainly it's not going to be exclusive usually either, because someone who is selling a software product will want to license out usage rights to many different people, many different customers. So it's not exclusive at all. A software license, again, is a license for intellectual property where the rights granted to you may be any of use, reproduction, adaptation, modification, etc., addressing all, at a minimum, all three core intellectual property rights that we identified that are key or relevant to software. Again, copyright, trademarks, and patents. So we've discussed intellectual property rights. We've discussed that licensees, in particular software licensees, are a contract between a licensor and a licensee regarding these intellectual property rights. And now we move on to open source software licenses, which are a special kind of software license. While software licenses are pretty free in their structuring, and they're really only limited by the ingenuity of the business person or the lawyer behind it. Free and open source software licenses are actually much more constrained. So these are software licenses that fulfill certain requirements. So they're a subspace or a subcategory of the overall set of possible licenses. Common to all of them, whether free or open, is that they're typically non-discriminatory, and newer licenses also all address not only copyright, but also patents and trademarks, of course. Depending on what license you're talking about, not only will you be given rights as a licensee, but you will also find obligations put on you. So you can structure software and in particular open source licenses into the rights granted to you and the obligations put on you, and only if both are valid do we look at a valid contract between a licensor and a licensee. Again, like with EULAs or end-user license agreements, there is no need for any signed contract. Open source software comes in effect when you actually use it, and then you need to make sure you're compliant with the license or the contract, that is. What constitutes, so we will now discuss the constraints or what makes up free Libre open source licenses. And for this, we need to note that there are two caretakers of these. There's on the one hand the Free Software Foundation, which defines and lists free software licenses or classifies software licenses as free, and the Open Source Initiative, which clarifies or which you can turn to get a software license approved as an open source license. These are actually not bodies of authority where you absolutely have to go to. But it's basically pragmatics which will make you go to the Open Source Initiative to ask them, would you consider my license an open source initiative, an open source license, and you get that approval by the Open Source Initiative putting your license by name on their website as a valid open source license. Let's start with free software. The motivation for free software is listed here in the form of the 4 freedoms, that if as a user you have these 4 freedoms, then the license which gives you these 4 freedoms is considered a free software license. It's the right, the freedom here if you will, it's the right to run the program as you wish for any purpose. Also, the right to study the program, which requires that you have access to the source code. The right, finally, to give pass on copies of the software, to redistribute the original software. And finally, the right to pass on a modified version of the software. The way how it's written here is a philosophy statement. This is not really a specific license. And it's also sufficiently vague to serve as an interpretation for or a vehicle of a checklist to see whether a particular license is a free software license. But in any case, you simply have a Free Software Foundation to make that decision for you. Here is perhaps the most well-known example of a software license that in the interpretation of the Free Software Foundation, the FSF, provides these 4 freedoms to its users. It's the GNU Public License version 2 as discussed in a prior session, and it's a lengthy legal text. So you cannot just take the 4 freedoms and say they apply to my software. From a legal perspective, that is too vague, that will not hold up in court, but rather you need a proper software license like the GPL version 2. The GPL version 2 is a copyleft license, sometimes also called reciprocal or with a connotation, I guess, viral software license. And it is basically a software license with a philosophy at heart or with a copyright-based strategy to fulfill these 4 freedoms, in particular to make sure that no software gets locked in. That's the notion of free here. The software cannot be held back by anyone who receives it and pass it on. So in copyleft-based licensing, there's an original licensor who provides the software under a copyleft license, like the GPL version 2, to a licensee V in this example here. And now the licensee V can only use the software under the GPL version 2 license and say their products if when they pass it on to any user U, that user then asks for the source code, they provide that source code of the original code or in its modified version or even in as part of the overall product, where they then may have to provide the overall product. So vendor V's software, proprietary software, as combined with the copyleft licensed software they received from P programmer. I say may because there's various tricky aspects to it that we will cover in a bit. So, I don't know, here's a short quiz from what I told you so far. Do you think that you can charge someone before you give them access to a copyleft licensed software? TA, please stop shortly and discuss this. So the answer is yes, you can charge. Nothing in the 4 freedoms says that you may not ask for money before you give someone copyleft licensed software, either in binary or in source code. However, once you gave them the software under a copyleft license, if you only gave them a binary, if they then come asking for the source code, you have to provide it. Still, for the original provision, you may charge money. The problem with that is why charging money won't really hold up unless it's for like a physical box or something. Is simply that anyone who receives it for you by way of the license can now make it available at a lower price or €0, if you will. So any margin is driven to 0 quickly, which is why people generally think you can't really charge for copyleft code. But at least, legally speaking, you can. You may just not find anyone to pay because they'll get it elsewhere for free. Copyleft and the rhetoric and the philosophy ruffled people's feathers, or at least some people's feathers, and so they poked fun at it. Here's one such way, the beerware license, where the author of this license defined the license to allow people simply to do what they want with the source code licensed under the beerware license. And for fun and kicks, the author said that they should, whoever uses the source code, then they should simply pay for a beer for the author. I don't think this qualifies as a free or open source software license properly, but it's certainly a fun aspect. So then the open source initiative as a second foundation to govern what constitutes open source software was a bit more precise than the 4 freedoms and defined 10 criteria for which determine whether a particular software license is actually an open source software license. And some of these criteria are pragmatic, some are more fundamental. Among the more fundamental aspects is that any license, so that for a license to be an open source software license, it must allow for redistribution. So if you get something under an open source license, then you must be allowed to redistribute the software for free, no royalty. Same thing, if you receive it under an open source license, then you must be able to receive, or you must include, the source code must be included. Same thing with modifications and derived work. So you may, as a recipient, as the licensee, you must be allowed to make modifications, etc., etc. Only then is the license an open source license. Of interest is also the non-discrimination aspect, because that's something people often stumble across or fall over, in that they may try to restrict the use of the software for whatever purposes. So if you don't like the military, you may be entitled, you may feel like you want to allow everyone to benefit from your software for free, except for any military purposes. Not allowed. Then your software cannot be an open source software, because criterion 6 here says that you cannot discriminate against any fields of endeavor. You cannot say these are the rights for everyone except for the military. Not an open source license if you do that. And some other things. Here is one of the oldest license, the Apache software license. Again, somewhat lengthy legal text written to include all these criteria in such a way that people can use the software, and that the software is an open source software because this is an open source license. Now then, there are lots of pragmatics associated with these licenses. For one, as you try to, as a licensor, as you try to license out some program code you write, you need to do it right. So, and you often the license actually tells you or points to, by way of associated pragmatic documents, tells you how you should license out the software properly, so that the license really is clearly and cleanly attached to your software. For example, in the root directory, we are usually talking about text-based, file-based source code here. In the root directory, you should have the license you want to apply. You need to remember or recognize there's a set of open source licenses, and as a programmer, you don't invent your own. You take just one of the existing licenses. So you take that legal text, and for example, the Apache software license version 2, and then you put a copy of that text into the root directory of your project. For you to be able to do that, these license texts, which are legal texts, are made available to you for free. So they are actually not, you don't have to pay anyone for the use of the license. And you copy the full license text, usually into your root directory as a separate file called license or something. You may also have to, or you may be highly recommended that you mark each file with a file header that lists the license. So for example, you can see here in a text file for, say, some Java code, you may have to provide, or you may want to provide that header that makes it very clear under what license this particular file is provided to its users, the licensors. And then a couple of others, we may revisit them later in the governance part of this course. It gets even more difficult if now you are someone, the licensor, who receives some open source code under a particular license. What do you need to do in order to fulfill any obligations put on you? It's called license compliant. Only if you behave in a license compliant way do you fulfill the obligations and actually are granted the rights as spelled out in the license, like free use, modifications allowed, passing it on. So in order to properly use, meaning being license compliant, you may have to display the original copyright notice. You may have to include any disclaimers about warranties not given to you or any other user you pass this on, etc., etc. In fact, license compliance is a deep and tricky subject and its own business. There are software vendors, there are vendors and consulting companies who help you with it, and they are charged a pretty penny because it's not trivial. For kicks and fun, here's yet another license, a bit more strong worded, and you can see what constitutes the most basic license is a name, so it can be identified, a name and a version perhaps. Then the actual, since the license is a legal text, how it can be used in this case. So the license as its own intellectual property needs the license. Here also do what you want. And then finally the actual license text as it applies to what the licensed content. And here it's as simple as is possible. Do what you want with it. These are the terms and conditions for copying, distribution, and modification of the work that is being licensed by this license, under this license. So since we are always discussing free versus open, is it the same or not? The simplest way I found to explain the difference again is that copyleft type of freedom, the original Four Freedoms by Stallman, care about the freedom of the software primarily, from which a couple of freedoms derive for the user. While the permissive freedom of the open source initiative, or say the Apache license, is to give the developer the largest possible degree of freedom. I say in copyleft the freedom is about the entity, the artifact, because you restrict what the developer can do. In particular, they cannot hide it, or the intention is to prevent them from hiding and closing the software. While the permissive freedom simply allows the developer to do just that if they want to. They don't have to. And an enlightened software developer will think hard about what they want to keep proprietary and what not. But in any case, they are not forced to, while the copyleft freedom tries to force developers. This forcing, or this copyleft effect, is another deep discussion. It certainly hinges, and this is the whole trickiness of license compliance and what the consequences are, the obligations put on the user in the case of copyleft licenses. It hinges on copyright law. In particular, US copyright law, since the licenses were all originally conceived in the United States and have spread since then. In US copyright law, there are two terms that then would also apply to software where copyright is relevant, which is collective work and derivative work. And the original copyleft effect applied to derivative works, but not collective works. Collective works you need to imagine as a collection of components, not strongly related or independent, if you will, and then having one of the components being licensed under a copyleft license, it will not affect the other components. While a component which is considered a derivative work will fall under the copyleft license and will have to be licensed under copyleft as well. And in that case, the derivative work in the most cleanest way is you taking some copyleft license code and modifying it changing the original file to be some new file, a modified version, and that then is a derivative work. What may sound intuitive, as I described it, in practice is everything but. It's simply spoken, there are different interpretations of how two software components relate to each other and whether they constitute a collective work or a derivative work. Usually the user wants it or claims it's a collective work because they don't want the downsides, the copyleft effect of a copyleft license, while the original licensor, the owner, will argue that it's a derivative work. You can read up on it on the web, whether, for example, two components statically link to each other or dynamically link to each other or link to each other through web services calls really constitute a derivative work. Or not. The difficulty with all of this comes from the Linux kernel, because the Linux kernel is licensed under the GPL version 2, a copyleft license. So any software component that attaches to the Linux kernel is it a derivative or a collective work. The original intention of Torvalds was, if something is in user space rather than in kernel space, it's a collective work. Copyleft does not apply. But already with drivers, it becomes difficult, and how closely linked are they to the kernel? So there are basically outstanding lawsuits trying to settle that, but I don't think it's been fully settled. In any case, putting next to each other the GPL version 2 and the Apache license 2 as two of the older and widely used licenses that are nice representatives of the category, you can see how GPL version 2 permits certain things and requires certain things and forbids certain things, and so does the Apache software license. So the GPL version 2 permits the use of the software for free, etc. And the Apache license 2 also does so, and it also allows redistribution of modification without open sourcing, meaning you can use Apache licensed code in a collective or derivative work with your proprietary code on top, and then you can pass it on without you having to provide the software under the Apache software license to anyone who comes asking. You can choose to only provide it under a proprietary license. So no copyleft effect here. That's, of course, what the GPL version 2 requires if you provide it to someone, your software, and it is a derivative work of some GPL version 2 licensed software code. Then if anyone comes asking who you gave it to, you may have to provide the source code, and you must provide it. You must provide the source code if you want to be compliant to the license. And also you also have to grant the user the same the source code under the copyleft license. Both then again have some same requirements, obligations put on the user, proper attribution, inclusion of the license and distribution, etc., so that it's marked what software is included, and also warranties are disclaimed, etc., etc. You never get the right to claim any endorsement, and you never always get the right to use any of the trademarks of the organizations behind the licenses. We will see in a bit that there are many open source licenses, and they all differ along these dimensions, whether they include copyleft or not, what exactly derivative or derived work is. For example, what about web services calls? Are these collective or derivative works, etc., etc. So here is a quiz. Let's discuss this. In a project, you use file X, which is GPL version 2 license. And now you do certain things, and is the result of your work a collective or a derivative work? Please discuss. Right, I hope you had a fruitful discussion. So case one, you change file X to become X dash, X prime, X dash. What? X prime. So this is probably a derivative work because you changed the file, so that really is a pretty clean-cut modification. You create a class A in file Y, which subclasses a file from file X. Okay, so you're not touching the same source code now, but you're really hooking into, and in all likelihood, this is a statically linked connection between them. Then the Free Software Foundation clearly and cleanly is claiming it's a derivative work. But you may disagree, and as long as you don't go in front of a court, you will not know. You create code in file Z, which uses code from file X. Like the previous case, there is a call probably involved here, depends on the linking mechanism. The Free Software Foundation, which pretty narrowly, which pretty broadly defines derivative work, pretty much wants everything to be a derivative work, will argue that it's a derivative work, but unless you go to court, you won't know. Statically link two files together into A, may or may not be derivative, we don't know, probably is derivative. To dynamically link this, may not be, it's completely open whether dynamically linked or statically linked code counts as derivative or collective code. Create file B, code of which makes a web service call. So for most interpretation, no, actually this one is actually clear. A web services call does not make it a derivative work. And we can conclude that because to cover this particular situation, the Free Software Foundation invented a new license because it actually did not want the GPL version 2 and the later GPL version 3 to make anything connected through a web services call a derivative work. So for that, there's the GPL version 3. So then we know GPL version 2 is not assuming that something that makes a web services call to a GPL version 2 license component is a derivative work, rather it is a collective work. Well, if you're an engineer, you probably thought, oh, so what if there's some component that is copyleft licensed? I will just introduce an intermediate layer called a shim, and that shim will decouple my proprietary code from the copyleft code. And so if anyone comes asking, because our customers saw that there is copyleft code and they come asking now they want the source code, we'll give them the shim, but not the proprietary code. And so we decouple proprietary from copyleft licensed code and live happily ever after. So you may actually wonder, how is that possible? There's a small trick here. Do you see it? Well, the trick is that for this to work, the owner of the proprietary code also needs to be the owner of the shim. And then the owner of the shim, so the owner of some intellectual property software, has a right to put multiple licenses onto some component. So here then, the shim will be given to whoever comes asking under a copyleft code. But since it's still owned by the proprietary code owner, they just don't care. They also maintain the proprietary code license, and so it doesn't actually propagate into the proprietary code. Nice trick. Anyway, so the GPL licenses are important, mostly because of the Linux kernel, and they're a whole family. They're not just one license. There is the original version 1 generation, which is irrelevant now, mostly. There is the GPL version 2 family, which is very relevant. Certainly the GPL version 2 is very relevant because the Linux kernel is licensed under this license. There was, or there still is, all these licenses exist, of course, they're just not in may or may not be in wide use. The LGPL version 2, which has a special provision for libraries, is being discouraged. So while it is still important, mostly because the glibc is licensed under it, its use has been discouraged. So there is, I believe there is, for compatibility reasons, another generation, version 3, but it's not really encouraged to be used. So the GPL version 2 is the important one because that's the Linux kernel license, and now there is a GPL version 3, and the reason is that GPL version 2 was done in the early 90s, I believe 91, while GPL version 3 is quite recent, 2013, 14, 15, something like that, and fixes a lot of the issues with version 2, in particular the emergence of things that were just not considered in version 2, which are, for example, patterns, but also things like web service calls. Because we now live in a much more interconnected world, web services calls are not triggering the copyleft aspects of GPL version 3, but rather this has been factored into a new license, the AGPL version 3, the Affero GPL version 3, which is like the GPL version 3, except that it makes web services calls, or determines that web services calls make the combined work a derivative work. So you can see how licenses evolve, and they're really called a license family. Most of these licenses also now allow the fixing of problems with these licenses that were unknown while the license was created, by way of a clause where it allows the licensor to relicense under a later license. So there's a clause in there where it says any code is licensed under this license or a later one in the family, giving the owners of the license family an opportunity to adjust, to create new license versions, later license versions that fix some of the problems. Sadly, again, the Linux kernel is licensed not only under GPL version 2, but under a special version of GPL version 2 created by Linus Torvalds, in which he took out that under a later version. So in all likelihood, the Linux kernel will always remain under GPL version 2 because it's not possible to upgrade it to a later version. I already discussed it. The version 3 generation addresses patterns. We'll shortly talk about that, and also made the whole GPL family more compatible with other licenses. Sadly, GPL version 2 is not compatible with the Apache software license for patent reasons. So here's a little small quiz. So there used to be a software forge called Google Code, and Google only allowed, initially they only allowed for 9 licenses, or they only gave you a drop down for 9 licenses, and that's it. We will see in a few slides that there are actually 70 something open source licenses and growing. So why only 9? What do you think? Well, so Google argued that there were just too many open source licenses out there, and it completely confused users. So the so-called license proliferation is a bad thing, and hence users should be given only limited choice. And as such, this is the reason why there were only a few licenses being shown. And while it was possible to provide your own license, you really had to type it in rather than choose it from a drop-down menu. Here's an industry pundit who believes there was another reason. And in particular, when he looked at the drop-down menu, he saw that the AGPL license was missing. And so Google Code, provided to you by Google, the company, allowed for Apache and GPL license code, but did not really show you the AGPL option. And naturally, since Google is an almost exclusively web services based business model, Google likes all kind of open source unless it's the derivative or the copyleft effects kick in the form of if web services calls are present. So this guy believed that Phipps believed that open source, that Google perhaps deliberately tried to keep away the AGPL license from open source programmers. And that would be, my point here is, it's a business strategy, and so a company makes choices naturally that are best for them. And so Phipps believed or argued that Google made a choice that was best for them, but not necessarily, obviously, then to software developers. So we talked about copyright so far, and may now have to cover now patents. Another big aspect of open source software licenses. The Apache software license has a patents rights grant, which says that if you license something under the Apache software license, then you grant everyone a right to use the software, including any patents in there that you may have rights to. So there's an implied patent rights grant for free, etc., like with copyright. And even more interestingly, there's a so-called patent retaliation clause, assuming that you as the recipient, the licensee, who received some open source component under the Apache license and are using it in your product, if you now bring a lawsuit against someone else for patents in this open source software because you put some code there into a modified version and now you're suing someone, then you actually, you're asking someone to pay patent, actually there's patent litigation, so you're suing someone to pay for the use of your patented code, then then you lose the right to use the software under the open source software license, under the Apache software license. That's patent retaliation. If you try to enforce patents, the rights given to you to use somebody else's patents are revoked. Patent retaliation. A way of how the software community or the open source community at least is trying to make sure that software patents are basically taken out of business. And so there are different variants of strength of patent retaliation. They may be limited to the particular open source component, they may apply much more broadly. So we discussed copyleft licenses, we discussed permissive licenses. There's something in between where really the copyleft effect applies only to modifications of files typically, but the combined work can be proprietary. Today there are more than 50 approved by the Open Source Initiative, active open source license, some 20-30 considered retired licenses, etc. Common to them all, of course, is you're just given no warranties whatsoever. They all require attribution. They all require that you may not use any trademarks by the original creators or the foundations behind it. In 2009, you can see a list here of open source licenses and rank ordered by use in open source projects, and you can see how the GPL version 2 is used by more than half of all the open source projects. So it's leading by a wide margin. In 2015, as you can see here, the GPL was down to 25%. So there was a huge surge in open source projects and not nearly as many as before were licensed under the GPL. Rather, the MIT, Apache, BSD license our permissive licenses were climbing in use and are, I think, by now even have overtaken the GPL. This has not gone unnoticed by industry, and some attribute it actually to the increased involvement of companies collaborating on open source software, not competitively differentiating open source software, so software that needs to be good, but otherwise it's just a cost issue, and that these software components, because they're used in products, are usually licensed permissively. And Black Duck, one of the vendors in this space, analyzed that and saw that, noticed how the GPL, the use of the GPL has been declining ever since. We did some analysis of the growth of permissive licenses, and we put it to the time frame in the 2000s, early 2000, 2001, 2002. So right after the dot-com crash and associated businesses crashing, we noticed how permissive licenses suddenly started growing stronger, and non-permissive copyleft licenses started also growing in total numbers, but at a slower rate than the permissive licenses. So here is a quiz once more. Provenance of contributions. So you're a software developer, and please tell me about each of the following scenarios. Who holds what rights and who has to sign off on what? So please discuss. So on company time, you make a contribution to the Linux kernel. What does that mean? Well, the rights to your contribution are held by your company, so they pay you for your work. And as I argue here, it's being contributed to the Linux kernel, so in all likelihood, you have to license it under GPL version 2. So your employer, the company, has to license the intellectual property it owns, the source code, under GPL version 2. As a side remark, it's not easy to contribute to the Linux kernel. In fact, it's almost impossible if you're a newcomer, so these are hypotheticals. So second case, in your private time, you make a contribution. Well, in this case, you are the owner. You decide that you want to license the software, and it's required to license the software under GPL version 2 should your patch make it into the Linux kernel. You adjusted some code from the web and contributed to the Linux kernel. Well, there's an original owner of the code on the web, so whether you can actually do what is described here, we don't know, because what is the license that this original code is licensed under? That determines what can be done with it. It might just be illegal, what you just did, meaning not leading to not a valid license situation. So you implemented a new cryptography algorithm and contributed. Well, that's either case 1 or 2, depending on whose time you implemented the algorithm. And for the source code, or that it's a cryptography algorithm, it doesn't matter. The implied question here is there a patent behind it? Well, then it may be tricky, because if you contribute to the Linux kernel, the GPL version 2 doesn't say anything about patents. So you might get it in there, well, and now you could sue everyone because you own a patent. And we won't discuss this further here. There are ways of how the industry fights back with patent invention, patent pools, etc. But patent trolls, companies, shell companies set up only to litigate, to own patents and litigate for license fees, are a real problem. Anyway, moving on. In order to overcome some of the problems that you get from just using licensees to a legally coordinated community. Open source foundations invented the notion of a contributor license agreement or a contributor agreement. That is another legal text, a contract, in which you, the person who underwrites the contract, actually spells out rights that you give to the foundation that is managing a project. So not only by contributing to an open source project under the license, under a particular given license, do you agree to the license. These contributor license agreements, in addition, make you sign over your copyright, for example, to the open source foundation. That is what the Apache Software Foundation does, the Eclipse Foundation does, even the Free Software Foundation, for projects under their hood, meaning where they are the official caretaker of that software. You don't have to sign a contributor license agreement to use the software. You don't have to sign it to modify the software. You just won't get your contribution into their space. You can always fork Apache projects and do your own thing, but you will not get it into the Apache code repositories if you don't sign the contributor license agreement. There are two variants of it. There's the full-blown copyright transfer, where you transfer really your copyright, and then there's the relicensing rights grant, where you grant the foundation the rights to relicense the software. The purpose of these agreements is such that the foundation can act as the owner and represent the open source projects in court, rather than having to draw on all thousands, potentially, developers to come together and agree on a strategy in court, for example. So pretty much all open source foundations require that you sign this contributor agreement before you can make a contribution. Because there's so many contributor agreements out there, there was an attempt to unify them, and I think that failed though. And some argue that the open source software license should be enough. There should not be a single entity that can act as a single legal entity, but others obviously disagree. So then the Linux kernel, because it was developed outside a foundation originally, the Linux Foundation where Torvalds is now employed came only much later after the Linux kernel development started. The Linux kernel uses a different approach. It requires a so-called developer certificate of origin, where every single contribution by a developer is linked to this developer certificate, and where electronically the developer certifies that this holds true, meaning the developer actually programmed what they did, have the rights to it, and etc., etc. And then there's a process in the Linux kernel where people sign off on this. The recipient of the patch, who may be a maintainer of the Linux kernel in some position, receiving it from the original creator, etc. All right. So finally, there is to note that licenses evolve. We had the example of the GPL family, and there are various things to consider. It's important that you have this later clause in there because it allows you to fix problems as the Wikipedia case, so not an open source case, but as the Wikipedia relicensing case shows. As noted already, you as an owner, you can multiple license source code, and that will become important for a particular business model, the single vendor open source business model later on. We also didn't discuss, but will discuss in future versions of, in future sessions, how software is built from many components, and then what it means that you have to combine licenses, different licenses potentially for different software components. So you can see a simple example here, strongly simplifying example, and you see 3 open source components, Jetty, Postgres, and OpenJDK, all licensed differently, and one originally, now also open source component, Wildsight, an application that I built, licensed under yet a 4th license, and you have to combine them, and it may or may not work. For example, the Apache software license cannot be integrated with GPL version 2 code for patent clause reasons if it was a derivative work, which it's not here. I consider it a collective work. The most important licenses are listed here, and you can see how there's compatibility between them. And we can see how MIT can be included in BSD, new BSD work can be included in Apache work. The Apache work, licensed work, can be included in LGPL licensed work, version 3, and GPL version 3 work, etc. But it cannot go the other way around. You only can follow the arrows here. You can't go against the arrows. That's it from me for now. Thank you very much for this lengthy and probably not for listening in on this lengthy and probably not so easy intellectual property discussion, but it is important to understand these aspects in general, to understand open source, and in particular to understand the various aspects in future lectures that we will touch upon. And they range from engineering processes, collaboration processes, all the way to the business models and business strategies that are now shaping the software industry. Thank you again, and see you in a bit.